these experts, okay, go through this. I've been through all this information. And so if you can go, using your experts, and your experts kind of can tell me and the state that you need to investigate particular people, okay, that were involved in this, then we can have a hearing about it. But I'm not quite ready to be convinced that without getting this information from the experts that we're gonna find some pathway, okay, that's going to be helpful to Mr. Kohberger.
I mean, this is
I don't
your
know.
courtroom, so if that's what you want to do, we can. I'm here. We waited a while to come to this hearing. I'm asking for it all with a protective order. If we do it the other way, we can do it. It's just everything takes time. And if that's the preference, that's okay.
I be living my life like that, man. Very accommodating, man. I said that about Ann. I recently frequented a particular area here in Florida, so on my journey back, home, I passed this bar. It's called Smoke. You guys stay to the end if you're interested in hearing that story, man. I know y'all came to hear about Bryan in Idaho 4, so we can get to that, man. And the rest of that's on the back end if you care.
Sure, it's necessary, but I'm going to keep an open mind about that. So for right now, I would say let's just get your experts looking at the IgG stuff and exactly what they can read from that, and we'll go from there. Okay. Now, with regard to your clarification, yeah, I mean, I'm not saying that your investigators can't contact people that they've already contacted without relying on the IgG information. That work for now?
Yes, Your Honor. Our mitigation expert has done her own family tree based on her work, and she has nothing to do with the IgG material. She's not an expert that would have access to that. She's not named. So she needs to keep doing what she's doing as far as her work goes. And I think the proper clarification is that the IgG materials will not be used to develop any investigative leads.
So that part tells me two things. I had a question of why was Ann so adamant that she wanted to be clear she could continue talking to Bryan's family. I think that kind of answered that question for me. She was asking on behalf of her mitigation expert. I won't go further into that right now. And also earlier the judge had said something like the state assured him, that the IgG evidence wasn't used to get a warrant, et cetera, et cetera, et cetera. And, it was his position that Ann and Bryan, by default, should take the state's word for it. That's why I've referenced that thing that happened in Young Thug's trial where the district attorney, assistant district attorney, Ms. Love, said, hey, we didn't turn these text messages over to the defense because, hey, they have nothing to do with why we're here. They were just pleasantries, only to turn around and spend like the next couple of hours and whatever extended time it takes when, the trial resumes, specifically questioning the witnesses about the text messages. So when the state says, hey, this has nothing to do with the warrant, etc., nobody, and the judge even says it, he says, hey man, it is your duty, Ann, to dig as deep into these things as you possibly can. So nobody is obligated or here to take the state's word for anything about how they gather evidence to prosecute a man they're trying to kill. But Ann said, hey, no, Judge, I think the correct, verbiage is, it won't be used in the investigation at all. Because I don't want you to come back later and say, well, I told you it wasn't used for the warrant, but it was used. No. The correct verbiage, the legalese we need here is it wasn't used at all. So that's what I gathered from her making those 2 points. I could be wrong, but, once again, that's what I gathered. I don't think y'all were expecting this.
I think that's fair. And what Ms. Jennings proposed in language in their response to your motion, is that something that you would object to at this point? I'm sure you probably read that language.
I did read it. It's a little bit less straightforward, but I think it covers it. It allows me to continue to speak to the people I'm speaking to and that I need to speak to that are on my list.
Okay. Anything else about that?
No.
These issues. Okay. Ms. Jennings?
No.
Okay, great.
This is Bryan's last hearing, man. Shout out to Honey B, I think her name is on Twitter. I seen she had posted Bryan has another hearing on April the 4th about, Ann's team, Ann's investigators questioning the general public or prospective jurors. But anyway, this is Bryan's last hearing. I've been covering this for the last couple of videos. So if you care to catch up, you can go watch them. Like, share, subscribe. I always feel weird saying that, man. Just hit the notification bell and check the channel.
Okay, the next question I had is, I know that Mr. Kohberger filed for permissive appeal to the Supreme Court, and I just wondered what you know about that, because I have heard nothing about that. I know it was filed.
I know the states filed their objection, and that's the last that I recall seeing about it.
Yes. So at this point, we don't know if the Supreme Court is going to take it. Okay, we don't know. You know anything else, Mr. Thompson?
Not other than the state's response was filed by the appellate division of the Attorney General's office. And I think we're just waiting to hear from the Supreme Court at this point.
Correct, Your Honor. We're just waiting to hear from the Supreme Court. I can tell you there's no deadline in the rule for them. They didn't include a deadline for themselves. And in my experience, it can take anywhere from a couple weeks to a month or so. So at this point, we're just waiting to hear.
So I don't know the answer to this. If it's filed, does that pause what we need to do here, or do we just pause it only when they pick it up?
See, I'm out of pocket here, man, because I did a video covering this, but a few hearings, well, maybe just the last hearing, man. Ann appealed a decision, or she asked the judge if she could appeal the decision he made to the Supreme Court. And I can't remember what that decision was. So if you guys don't mind helping me here, I think it may have been about what IGG evidence he handed over to her. I can't remember, guys. Help me out there. I'm confused, though. In that hearing, part of the state's argument was, hey, if we send this to the Supreme Court, it's going to prolong, when we could set a trial date. And Ann's rebuttal to that, which she didn't argue that, one of the gentlemen on her team did, was that, hey, man, this won't extend the trial any further than it is now. And to be fair, I just got to be fair. And he was right, because now the judge himself has extended the trial by saying Ann's detectives, I think, inspectors, investigators can't see, the IGG evidence that has been given to her until her experts say, hey, no, we do need to investigate certain people. And then they want to come and have a hearing about that. So that doesn't even guarantee that her investigators will be allowed access to it. It's just that, hey, now we'll go further into the discussion. So once again, when the gentleman, I can't remember his name, said, hey, what we're asking won't extend the trial or prolong the trial any further than it already is, he's right, because we've already ran into another, extension through no fault of Ann. The judge is responsible for it. So I'm just confused why. Number one, you should have granted Ann's motions back then based on the logic of what came, in the future. Obviously, we couldn't see that, but still, hindsight being 2020. But still, you sit on that stand asking the attorneys what's going on in the case. And once again, this is where I fall back on, I don't have any litigation experience. So maybe there's just so much going on that makes sense. I could see how in a sense it would. But what you really get me is when you ask them, does this mean that we have to pause what we're doing now, sir? This is when I'm like, are y'all high or is it just me, right? I'm gonna be honest with you guys. I'm sitting at the park, like it's this beautiful little park, and you can see this pond and the birds fly here. I just like serene and peaceful things. So, I wanted to continue this video, so I'm here. And I'm like, is it me or the world that I'm looking at is crazy, man? Because these people asked you for something, and the foundation of your objection and rejection of what they were asking is you didn't want to postpone setting a trial date. Now, sir, you have postponed the trial date, and even after that, you sit on the stand asking the attorneys, does the decision, whatever it is that you're waiting on from the Supreme Court, mean that you guys need to pause? Why in the hell, when Ann suggests pausing the trial to prepare the best defense for her client, is it outrage? Like, nah, we just can't do that because, we got to do it so people can park. We got to do it because the living loved ones of these 4 deceased victims need this to go ahead and happen so it won't be hanging over their head, adding to the grief they already feel. Like, we got all these excuses when Ann needs to, hold things off a little bit to prepare what she feels is the best defense for her client. No, hell no, we can't do it. Why are you asking for this abomination? But in all these other situations, it's we will postpone. It's okay if we have to do it. And do we need to do it? Now you are accommodating, sir. How in the hell did you become? Ann is supposed to be the accommodating one here. You are not playing your role. Now you all of a sudden accommodating, and it's pertaining to something that you absolutely don't want to do anytime it's suggested by the defense, which is postponing your availability and ability to set a direct trial date. I'm confused as hell, and once again, I just fall back on the damn question. Is it me that's high here, or is it this damn general public that I'm looking at? Let's get back to the video, man.
My read of the rules, Your Honor, is the latter, that we continue as we are, unless and until they decide to take it, and then they would decide at that point what exactly is paused and not paused.
What the hell you think he gonna say, man? These the same folk that want to go to trial before they have all the evidence and before they hand it over to the defense. So you ask him, like, yo, do we need to hold on so everything will be done right, or we need to keep going? What you think he gonna say, man? Be for real, bro.
Okay, thank you. Anything else about that, Ms. Taylor?
No, thank you, Chair.
Mr. Thompson?
No, sir.
That's one of those moments when Ann not saying anything tells me one of two things, man. That, I can be comfortable or confident in the outcome, Ann picks and chooses her battles well, man. So Ann didn't say anything. So hey, man, we're gonna see. We're gonna rock with it for now.
All right, I think we're now to schedule. Starting with, there was a request on change of venue, maybe late April, you were saying.
Yes, Your Honor, either that last week of April, I think it starts the 29th and 30th, or the first or second week of May for the actual hearing is when we'd request. And we would ask that we have until maybe the second week of April to get our initial briefing in, and then the state's response and our reply after that.
So what are you thinking would be the hearing? Like, give me a day or a week.
I would say that first full week of May, maybe that's May 5th or May 6th.
It's entertaining, man. But you got to remember, okay. How we got here. But just to watch some of this stuff is it's unbelievable.
Baby, Ben. Right.
Your Honor, we're asking the court to either deny this motion for change of venue as premature, or to set a hearing date closer to the trial date when that trial date gets set. And the reason for that is when courts look to change of venue and whether or not that's appropriate, the courts look to affidavits that have been filed. Importantly, they look to what prospective jurors say during the voir dire process. Another thing that courts look to is the amount of media coverage and the proximity of that media coverage and the intensity of that media coverage to the trial. So in this case, I think we don't have sufficient information to even determine whether or not that's appropriate without seeing what prospective jurors actually say.
These folks so phony, man. I'm telling you, I'm telling myself while I'm listening to this, make sure you listen to what the ladies say, man. We are all, not only capable of, but willing participants. And if you want to be sympathetic to yourself, victims of internal bias. And I do mean our own internal bias, not other people's internal biases towards us. Both are true, but I'm only referencing one here. So I'm telling myself, don't just be, because I already feel a way toward the state. I'm going to be honest with you. For many reasons that I won't get into, but they have earned it in this particular case. It's not just personal reasons or internal bias. Like, I personally do feel like, from watching the state from an impartial perspective, that they have earned it in this case, and this is just another incident and more indication why I feel like that. The lady says right now, it is so ironic that I'm going back reviewing this. Hey man, one of the criteria that the courts look at is knowing how close the media coverage was and how it has affected the potential juror population. That's what she says. But right now, shout out once again to Honeybee. Aren't y'all like? I didn't see the part where the judge blocked Ann's team from interviewing potential jurors, but apparently that happened according to what's being said online. But so y'all blocked her. Like, so part of her argument is that this is why we need to change the venue. And then you agree with her that when courts are considering a change of venue motion, that what they consider is how much the general public has been affected by media coverage and the proximity of that media coverage. So Ann said, okay, cool. Since this is going to be something that the courts look at, let me go out here and gauge it. Damn it. I mean, what do you want her to do? You want her to come to court like you and say, well, judge, you can take our word for it? I don't think the judge is giving her or anybody watching these proceedings any indication that he's going to take her word for a damn thing. She gonna have to prove it. Didn't he just tell her, yo, your experts tell me, yo, the investigators need to look at it. We good. We can come in here and talk about it. But you saying it isn't enough. But on the same side, the same judge in the same hearing said, well, hey, the prosecution told me this. Why isn't that enough for you? It's enough for me. And now you basically want her to, one of the things that the court has to consider, she needs to be able to bring evidence of to court, but you don't want her to be able to gather the damn evidence. Just say you ain't got nothing on this damn man and let us, come on, bro, you killing us, man. You killing us, man. Every damn avenue that she has to explore her client's innocence, you want to close. And your has already admitted, I shouldn't even say that word, you've already admitted that you don't want to explore some potential avenues that, I ain't no conspiracy theory type person. I'm more of a fact. If it leads somewhere, we should be able to put some tangible fingerprints on something that something says leads somewhere. I mean, come on, bro. The tangible, there's as much evidence that Bryan is guilty of these 4 murders as there is that y'all are involved in some type of conspiratorial cover-up. I'm just being real with you. There's as much evidence. So if Bryan is guilty of these murders, then y'all are guilty of a conspiratorial cover-up. If not, I refer to my last damn video. Why don't you save us all the heartache, the time, the grief, the worry, the concern? It's a lot going on out there in Idaho, bro. Maybe they bought a hook, line, and sinker, but I personally haven't. Why don't you, the family, you talking about the families need to get this from over their heads, so they can deal with the grief that they can do nothing about but deal with? Then why don't you assure us that you have this man dead right? Why don't you? And why don't you stop trying to thwart all of his attorney's moves to prove he's innocent, damn it? That's crazy as hell for this lady to sit there in court and say, well, we know that one of the things the courts consider is the exposure of the general public, the potential juror population, to what's going on in this case. I don't know if she said how they feel about, the information they've been exposed to, but I read the, motion Ann's filed and what her expert had to say. He mentioned not only do they want to measure their exposure, but also their feelings toward what the information they've been exposed to. I don't know if she said it, but she definitely said, we understand this is something the court considers. Why the hell are you trying to stop? And she has to prove that. Let me say this one more time. We're going to get back to the video. She doesn't have the luxury of just coming to court and letting the judge take her word for it. You don't got to believe everything I'm pointing out. I'm also pointing out why I'm pointing these things out. I ain't just making things up and leave. My name ain't Nancy Grace, WFLAG. I ain't better than none of them, but I'm damn sure not them. Back to the video. We don't know without knowing what the prospective jurors have to say. How the hell is her and or anybody gonna know what they have to say without asking them, man? Y'all crazy.
We're far enough out from trial that we can't really gauge that anyway. So we would ask the court to either deny that motion at this time or to set a hearing further down the road and closer to trial. If we do proceed to hearing, the state would just ask for a scheduling order. At this point, the defense has filed a motion. They did not file any affidavits, disclose any experts. They haven't even filed a supporting memorandum. And so we're not even sure what specific cases they're relying upon. So we can't really respond substantively to that motion until it's briefed. So we would ask the court to set a briefing schedule as well. Thank you, Your Honor.
Okay, thank you. Well, my interpretation was that they were going to give us a lot of information, affidavits, maybe testimony for the hearing. Is that right, Ms. Taylor?
Your Honor, you're right. The motion was to put everybody on notice that we'd like to have this addressed. We do intend to have a presentation for the court. We do intend to have briefing for the state. I anticipated we'd get that scheduled today.
And ready to go on.
But no, I didn't file a motion. I filed it to put everybody on notice that it's coming, and I think we need to address it. I think we need to address it before a trial setting. It doesn't make sense to set a trial, get right up to it, and then have to have everybody who's under subpoena rescheduled and have to have the public and the families of everybody disappointed because we're going to reset it at the last minute. So I think we should take care of whether or not the court should change venue sooner rather than later, especially given the length that this trial is anticipated to go. We'll need to schedule a courtroom either here or in another county in Idaho. I mean, we'll need some advance notice to get that done because it'll take a long time to try this case.
I'm gonna keep it real. I didn't even notice that, and I'm not gonna say it was a bad argument because the state is arguing, hey man, just get rid. We don't even talk about this. Get it off the table, judge. Say no. And they also saying if it does happen, this is how we would like, it to proceed under these guidelines. But I didn't even peep it until Ann pointed out, like, they're kind of, no matter what, they're forcing themselves into a position where they have to argue against their own argument. Because remember, I reminded us that part of Bill's argument against, and appealing to the Supreme Court was the need to expedite this trial as an offering of generosity and sympathy toward the remaining surviving loved ones, right? That was a huge part of his argument. They have this hanging over their head. We can at least get this out of the way for them. And now part of his team is arguing, hey man, let's postpone the trial. And it's Ann up there arguing, hey man, if we do it like they're saying do it, then we got to get everybody here just to send everybody home and say we got to redo this, which part of that everybody would be these remaining surviving loved ones. So it's like, that's what I'm saying. This when I say the state earns, the skepticism, it's things like this. And Ann is so eloquent and sharp with it too. And I don't even think in some of these instances, she's just trying to poke the bear. It's an obvious opportunity presents itself, and there's no way for me to respond to this except to, get my point across, which will expose what you've represented yourself to be. So I just thought that ironic because I've listened to this before, but I didn't even peep that Ann exposed them actually contradicting their own argument here as she took up their argument for them based on what they were trying to argue, the outcome they wanted. So what do you want, state? Do you want to postpone the trial for your own obvious reasons, or do you want to get this out of the way as an extension of grace for the surviving loved ones? Logical minds want to know.
Thank you, Ms. Taylor. Thank you, Ms. Beatty.
And Your Honor, the state is asking for a briefing schedule so that we're not in a situation where the state is learning for the first time during a hearing what experts the defendant might be calling and what their arguments are. We would ask that all of that information be disclosed prior to hearing, including the CVs of any experts that will be testifying.
I know y'all heard what I just heard, right? We would just simply like discovery so we can prepare an adequate response. I cannot be the only one who finds it very ironic that the state is saying that. I'm going to repeat that, and then I'm going to say a little bit more. We're going to get back to it. The state stands before the court and says, hey, we just want all of the information we're entitled to so we can prepare an adequate response in an adequate amount of time, not last minute, right? What puzzles me more about this is that any sane mind doesn't get the irony here. It has not been the state who's come to hearing after hearing saying, hey, judge, These are things we're still asking for, very accommodating and very graciously saying we don't even believe it's the state's fault that we haven't gotten it yet. We believe they're being held up by other agencies, entities, and partners. But whatever the case, we haven't got. It has not been the state that has been coming to court for well over a year now saying that. Yet it is the state that stands there now saying, and also, may I add, also trying to go ahead and rush a trial date. That is not the state, defense doing that. So the state is on one hand trying to rush the trial date and now presenting it to be that they would like to have all the discovery they're entitled to legally, while they've been also the ones, and has not tried to rush the trial date. I stumbled a little bit here, and she's been the one begging for the information that she's legally entitled to. No matter how I stumble, if you've been watching this trial, you see what's going on here. It puzzles me more than anything that sane and rational minds can pretend they don't get this. Because now the argument is about Bryan's alibi and all these other things, bro. Just get back to the video, because the simple irrationalness of the logic infuriates me.
Well, that's certainly what is bad. But it's quite sticky, right? To think, you're going to wait until ready to seating the jury, which is probably a 2-week process in this case. Their
anti-justice argument to Ann's presentation and request was so ludicrous that the judge who definitely seems to be backing them at every turn and every occasion had to tell them, it's ludicrous, man. Not only are you arguing against your own prior argument, your argument is ludicrous, man. Man, shout out Judge. I guess the sun shines on even the dog sometimes.
And then figure out, hey, we can't see the jury, so we have to move the trial. At the same time, how do you really know if there's some prejudice without trying to see the jury? It's really a catch-22.
And all of the logistical concerns that Ms. Taylor is describing are totally correct. The problem is that is what the law requires, and that is what the case law says. The case law does contemplate that. So certainly it's correct to note that there are going to be logistical challenges to that, but that's what the case law requires. But even if the court weren't inclined to wait until we're actually going through the voir dire process, at a minimum, I think it would be appropriate for the court to look to some jury questionnaires and at least go through that process.
Okay.
I'm gonna be honest. I could understand what she was talking about there, but she had me so lost with that last argument. I don't even care.
This morning I was looking at State versus Haddon, where that was, you're probably very familiar with that, but that's Court of Appeals case, 2012, I believe. And there was a request to change venue well before the trial. The judge denied that, and then it came up again when they were trying to seat the jury, and then the judge denied that at that point. But kind of a double step to figure out if it was necessary. I've been struggling with this, for months. And so it's hard to know. Now, that doesn't mean that one of the parties can't present evidence. And the standard is kind of squishy, in my opinion. But they can provide that kind of information well before the trial. At the same time, I want to make sure that the state has the opportunity to respond to whatever information the Mr. Kohberger is going to present. So now I'm scratching my head about, is May, first week of May, does that allow enough time? Does that allow enough time for you, Ms. Taylor?
Your Honor, I think it does. I can present the information to the state. I can have my briefing, and I can have affidavits and let them know of any witness that I want to call. I can do that. probably by the beginning of the second week of April. And that would give them, if we do this in May, that would give them ample time to read it over and respond to what we intend to present.
Man, Ann is running circles around these people. We're probably gonna watch the end of this change of venue argument. There's a lot left of this particular hearing, man, and then we're just gonna carry it over to the next video, Lord willing. But why we yet again, Judge has forgotten his role as the authoritarian backup quarterback for the state, and now he's trying to assume Ann's role as the accommodating litigator here. Like, what he asked her, does the time that she laid out, from May to the first week of April, or was it backwards, April to the first week of May, you know what I'm talking about, was that enough time, as if he wants to extend it, because his point is he wants to give the state time to respond to whatever she presents, at a hearing, which is understandable. But that's what I'm saying. You see how easy it just makes sense to me, and no matter how I feel about either side, I say it's understandable. That's what you don't get, from people in a lot of cases, that instead of just going with what the facts are and what's logical and what's reasonable and what's tangibly there, we just go with our feelings and emotions and egos and biases and bigotry, et cetera, et cetera. But you are once again asking Ann if you need to postpone your ability to set in stone trial date, sir. If you're still arguing about a change of venue, how can you set a trial date? I don't know. Maybe I'm missing something there in my inexperience at being a litigator here. But if you're still handling pretrial business, it's just very difficult for me to believe that you're able to set a trial date. Someone can please correct me if I'm wrong. I'm not afraid of correction or being wrong. But you're asking this lady basically, sir, in a very accommodating tone, do you need to postpone things? But the irony is you're not asking it for her benefit. You're asking it for the state's benefit, which I don't have a problem with in and of itself. It's just that you never seem to lean this way towards Bryan and his defense team. It also puzzles me why you always refer to things as Bryan. It's like you're trying to keep his name before it's as a suspect. Maybe I'm just reaching there. But you definitely are asking Ann if you need to once again, to me, add more pretrial business before the trial date, which seems to me that means you will have to postpone your ability to set a trial date. And you're asking her that on behalf of the state. And it is once again Ann saying, no, we don't need to postpone anything here because I can be ready. If I tell you I can be ready, I can be ready. It's not me. I just want to do away with this narrative because y'all are doing that. And part of the reason you're doing that, you're putting that insinuation into the atmosphere, is to further slander my client for these crimes that you've accused him of. This has nothing to do with me or my client. This is y'all. You keep doing this. This is the second time in this hour and 22-minute hearing within the first 30 minutes, sir, that you yourself, no, it's third time. First time you actually postponed your ability to set a trial date. And the next two times, you reference your willingness to further add pretrial business that will very potentially, I don't see how not postpone your ability to set a trial date. But your main gripe, sir, is getting this trial date set. I'm no litigator, bro. I just go on logic. If you put 1 and 1 in front of me, I'm going to say it equals 2. You cannot put 1 and 1 in front of me and try to explain to me how I don't want to talk. Listen, are you trolling me? You joking? We just having fun here? Because if you're being serious, I don't want to have no conversation with you no more. You crazy as hell. You need mental health, assistance or something going on with you. I don't know. But I don't communicate in stupidity if I don't have to. I got enough of that going on in my own life, sir. You can't keep saying you're willing to postpone trial for your reasons, for the state's benefit, and then you want to keep telling us the reason you can't postpone trial when Ann needs it is because, hey, man, we got to get this going. I'm pissed off saying this repeatedly in this video. We're going to watch the rest of this. Hopefully it doesn't last too long so I can get the hell out of here and do something to calm down a little bit. Look at these pretty flying birds in this slowly floating water. We look like some algae or something on top of it. And we'll be back. Like, share, subscribe, all that weird stuff, modern people be saying. I be saying it too. But more than anything, just hit the notification to check back, man. Innocent until.
Thank you. Ms. Beatty, what are your thoughts?
Your Honor, as far as the duration of time between the briefing and the hearing, the state has no concerns about that. The state would just have concerns about those factors that the courts require us to look to as far as the timing of the hearing compared to the timing of trial. But as far as a briefing schedule prior to the hearing itself, that timeline makes sense to the state.
They with it. You trying to find a
Well,
reason to postpone it
let's
for 'em.
explore that just for a moment. Because I've been thinking about setting a trial.
That's all y'all think about. Legally prepared or not.
Well, and also for months, but I listened very carefully to Ms. Taylor and Mr. Thompson at our last hearing, and I really, it wasn't clear that I'm not really happy about setting the trial in 2025.
Innocent until, whether you are aware or not, you just watched 30 minutes, minimum, maximum, of this young man, this gentleman, giving us reasons why he is willing to postpone the trial, even doing, one motion, one action that actually will postpone the trial, telling Ann's her experts can look at, the IGG evidence that that's been availed to her, that she's been given. The partial, let's not forget, it's not the full, it's not what the state has, that they assured the judge has nothing to do with nothing anyway. It's not that, but she, they gave her a little something. And if her experts say that her investigators, because up until now they can't see it, but if her experts say, hey, we do need to investigate this, that, or the other, then they can come back to court and have a hearing about that. That's definitely going to postpone the trial, because if Ann has information that her investigators need to investigate, but they're being forbidden to do so by the court, obviously that needs to be resolved before you set a trial date. That a defense will need to be prepared. Anyway, I'm saying too damn much. You just watch 30 minutes of that judge postponing the trial date his ability to set one, and him at least 2 or 3 times referring to his willingness to do that. And we're going to end this video with him saying that's the last thing he wants to do. He's upset that he may have to set a trial date further out than he wants to, because he just doesn't want to. But he's willing to if it benefits his considerations or the state's. You've listened to Innocent Until. If you made it to the end of the video, it may or may not be a surprise on it. The intro to this video, I'm thinking may have made it to the outro, because I don't want to do something before I do something. But I appreciate you guys, man. I said it several times in the video. I do hate to be redundant, man. YouTube notifies when they do and don't want to. So at the very least, if you don't have the notifications on, maybe you just want to check the channel here and there, man. I'm from the South. I'm residing in Miami. It's beautiful today. And I hope you're enjoying life where you're at, man. Pray for everybody. Nobody better than nobody. Remember my babies. Cody Bixby, Lena Sadar Kill, Baby M, and what's her name, man? How can I forget her name live on video, man? I'm going to stop it and come back and tell y'all her name, because I got to. I ain't even have to. The devil is a lie. As soon as I click stop, yeah, I can't. Come on, man. Madalena, because I got 2 babies named Madalena. I got Cody. He's the only boy. Then I got Lena. It's not Madeline. Her name is not Madeline. Her name is Lena. And then I got, Baby M. And then Madalena. Madalena disappeared. Well, one of the last things that we seen of Madalena was her getting owner off, I think, off the bus. But anyway, man, pray for everybody, man. I'm out.
Listened very carefully to Ms. Taylor and Mr. Thompson at our last hearing, and I really, it wasn't clear that I'm not really happy about setting the trial in 2025.
You know we're going to talk about that, right, Lord willing? Your handshake ain't matching your smile, Judge. Shout out to you if you made it this far, man. That was another intro to this video, man, the original intro. And I mentioned it several times in this video where I said, I referenced the Young Thug trial and some things that I had noticed while I was watching it. But I couldn't in good conscience add another 17 minutes onto this video. So I'm saying all that to say what I'll end up doing, guys, is uploading it first to the members only for my little 2, 3, 4, 5 members, how many of it is y'all, man. I appreciate y'all for real, from my heart. Good looking out. And then a couple of days later, it'll come out on the channel, man. It'll probably be like something American Justice Lost Files, some just ranting and raving about, thoughts that got through away. But this is only part 1 anyway, so we'll be back, Lord willing, with part 2. But just look out for that if you care to, man. Once again, y'all be safe, and it's until.
Death can never take pride in that blow, cause the king beat death when he died and he rose.